Hello, this is Matt on the Moon Family Said Dan channel. Here's a headline from the Crypto Basic. Ripple versus SEC. Why do they always write that backwards? It's SEC versus Ripple, but that's how I'm reading it how they wrote it. Ripple versus SEC. Former SEC lawyer says there won't be monetary recovery for early XRP investors. Now, this is a topic that has been brought up a number of times over the years, but precisely what was stated here I'd not seen before. And ultimately, two attorneys within the XRP community ended up jumping in. Attorney Bill Morgan and then attorney Jeremy Hogan also had a couple brief comments, and I'll share all of that with you. But it's basically what we're getting at is this idea of because of statute of limitations, if enough time passes, you actually can't get monetary. I'll get the precise words for you, but it was something along the lines of monetary compensation. They brought up the idea of disgorgement as well. But the idea, again, just being so much time has passed, there are limited monetary penalties. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, in we go. Former SEC attorney asserts that there won't be monetary recovery if Judge Torres rules that XRP sales between 2012 and 2015 are securities. Now, that was interesting to see. That sounds, favorable to Ripple in general, and it's coming from a former SEC attorney. Piece continues. As the lawsuit between Ripple and the SEC approaches its end, crypto community members and legal experts have been discussing the possible outcome of the case. In a tweet yesterday, a former SEC lawyer, Mark, how do you say his last name? Fagel. There's another way I could potentially pronounce it, but I'm not going to do it. I'm not going to do it. Let's go. I'm going to go with Fagel. That sounds like a stupid made up name, but I'm going to go with that because I don't want to try the other one. So let's call him Fagel. Just have names that are more intuitive to pronounce, and then I don't have to go through this. So in a tweet yesterday, a former SEC lawyer, Mark Fagel, #nailed it, disclosed that there won't be monetary recovery if Judge Torres rules that early XRP sales from 2012 to 2015 are securities. Fagel made this known after an XRP community member raised a question regarding a recent Unchained podcast interview with Jason Gottlieb, a partner at Morrison Cohen. In the interview, Gottlieb said the SEC cannot charge Ethereum founders with offering unregistered securities due to a 5-year statute of limitations in place. According to Gottlieb, Ethereum was issued before 5 years ago, which makes it difficult for the SEC to make a move against the cryptocurrency. And so you may be thinking, and rightfully so, but what gives? Because some of the stuff that the SEC has been talking about having to do with Ripple goes back to the beginning of time, effectively. So what's up with this whole 5 years thing? Well, it's a bit of a nuanced approach, but that attorney Gottlieb brought that up, and there actually is something to this. So there's a member of the XRP community who shared that clip, goes by the name Snipeforce, and wrote, "I am questioning this statute of limitations take." Attorney Gottlieb says there are lots of asterisks, but XRP started trading in 2012, lawsuit was in 2020. That's 8 years. Can't that be Ripple's defense? Why spend all this time and money fishing for all sorts of stuff to beat the SEC? And that is a fair question, though I will notice as far as when XRP started trading, it was at some point in 2013, not 2012. But setting that aside, this is where former SEC attorney Mark Fagel jumps in and actually responded to this XRP community member and said, the SEC alleges that they continued selling XRP as part of an unregistered securities offering through 2020. So the case is not barred by the statute of limitations, though any monetary recovery is limited to the 5-year period before filing. Now, folks, I don't pretend to be a lawyer. I play one on the YouTubes. But, I know I'm not an actual lawyer. I hadn't actually heard that before, and it's fascinating. And so XRP community member and attorney Bill Morgan jumped in and responded to that, and he said, So if Judge Torres finds early sales of XRP from 2012 to 2015 are investment contracts, but not sales after 2015, there is no monetary recovery. And former SEC attorney Mark Fagel jumped back in and he says, correct. Under a recent change in the law, I believe they could get non-monetary relief, i.e. injunctions, bars. But I don't know if that would apply retroactively. And then Attorney Morgan says, if Ripple's current sales are only to on-demand liquidity customers, are not investment contracts because the ODL customers are not investors and use the XRP for cross-border transfers, the SEC could end up not obtaining an injunction of future sales and only limit monetary relief for early sales. So interesting concept. And then Attorney Fagel jumps back in and says, that's one way the court could, that's one way for the court to split the baby. Indeed, if I were a betting man, I'd guess the court finds Ripple liable on the merits. I think that's an easy case, but denies injunctive relief, perhaps punting on the issue of whether subsequent sales of XRP involve securities. Yeah, well, look, I don't know. As far as how the judge rules, as far as any potential Ripple violation, to some degree, I think about everything that's been argued. I just kind of shrug my shoulders. I'm just like, maybe she finds something that's not crazy to think. But in the end, as I always go back to the same thought, which is even if that happens, as long as she understands, and I think she does, the importance of providing clarity for secondary market transactions, so that we as XRP holders have a path forward. Well, that's what most matters to us anyway. So, I mean, we'll see here. But Attorney Hogan jumped in and wrote to Attorney Mark Fagel, formerly at the SEC, and Attorney Hogan said, the law, a tag-along to a defense spending bill, I think, explicitly applied retroactively to equitable relief, and there was a case, Liu versus SEC, which held that disgorgement was an equitable relief. So it was allowed, okay. And then Attorney Morgan responds to Attorney Hogan, and Attorney Morgan says, wasn't that the case, though, that said that the disgorgement needed to take into account or offset against the income earned for the impugned activity, the expenses earning that income? And Attorney Hogan seemed to think, yes. He said, Bill, looks like you are right, as usual, that it was the Liu case. And as far as that one, then he clarified part of the reason that he knew about this. It was from he said the library case here. And so Attorney Morgan wrote, I'm all over these cases, with a little laugh emoji. Actually, I cheated and just relied on what library's attorney said about the case. In fact, he raised an issue about whether you even get disgorgement on a Section 5 case. And then he shared this little screen grab. This is from the library case. If you want to read it, it's on your screen. I don't think it's necessary for the purposes of this video, but there it is if you do want to see it. Then there's somebody who wrote to Attorney Morgan and said, so does this mean a positive outcome for Ripple? ? And here's what Attorney Morgan had to say. The thread and comments relate to a type of remedy, disgorgement, if Ripple loses on liability. The gist of exchange with the former SEC attorney is that the SEC may obtain no disgorgement if the judge only finds Ripple XRP sales up to 2015 were investment contracts. I also cover the possibility that the SEC may also not obtain a permanent injunction on future Ripple XRP sales, as current XRP sales are to on-demand liquidity customers who are not investors and don't expect profits from XRP sales. Now, that I'll say this, that part is crucial if you're Ripple, because if there actually were an injunction against XRP sales, I mean, at that point, it's just like Ripple would just have to cease to have anything to do with the United States, because that won't work. You're basically destroying their on-demand liquidity product in any corridor touching the United States if you do that. So if that happens, okay, I think that'd be stupid as hell, and they'd fight that and probably win, even if it takes getting to the Supreme Court level. But that would be a disaster scenario for Ripple that just wouldn't be allowable. It wouldn't even work. So again, it doesn't seem like that's what's probable based on if I'm reading Attorney Morgan here correctly. But I don't know. Sometimes there are bad rulings. I'm optimistic, but we'll see what happens here, folks. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.